right? As we're going to talk about later on, one of the most important functions of precedent is that it allows you to make at least an educated guess about what might happen if you go to court with a particular case, because you can look at how the courts have decided similar cases previously, right? If you didn't have that, you wouldn't know whether it was a good idea to go to court, you wouldn't be able to assess the strength of your case, and you'd be much more adrift when it comes to actually vindicating your rights or obtaining resolution of a dispute in the courts. Now, what happened in Roman law is that over time, Roman law began to grow stagnant. It became stagnant because decision makers became more and more obsessed with codification. And they were concerned only with interpreting and applying those codified legal principles at the expense of encouraging a living tradition of dispute resolution. So it became more about what the law said than whether or not the way the law actually functioned when it was applied to disputes actually resolved disputes. So there emerged a disconnect between the law in principle and the law in practice, between the law as it existed on the books and the law as it impacted on society as disputes were attempted to be resolved, right? At the same time that we see this growing stagnation within Roman law, we also see the rise of the Christian church. The Christian church created problems for Roman law because the Christian church took the position that the laws of human beings in the conduct of their daily life, which is what we saw within the 12 tables, were secondary and less important than essentially the laws of God, right? So the laws of God, which were at that time largely unwritten, okay, and existed primarily at the level of principle, came to question, or threw into question, the legitimacy of written law created and comprised within the 12 tables by human beings. Around the 6th century, the Emperor Justinian